In different countries or even in different provinces, there can be different philosophies about how to approach youth justice. And in this class, we'll talk about 5 different models of youth justice. And I've shown a graph here that basically depicts a political spectrum or an ideological spectrum from the welfare approach to the crime control approach. Generally speaking, the ideological perspective on this graph reflects more left-wing views to more right-wing views. So starting from the welfare approach is more left-wing, moving through to the crime control approach. In Canada, we have what we call a trifurcated approach. And that means, as I mentioned before under the YCGA, that there's a tendency to respond to different types of youth involved in crime depending on the level of severity of their offense. You'll also notice the province of Quebec flag featured here, and I've placed them separate from Canada, not because I'm suggesting that they should separate from Canada, but because they are able to kind of, under the Quebec Act, do their own thing, and they tend to follow a corporatist perspective. And I'll talk in detail about what each of these 5 different models actually mean. When we look back at the history of youth justice in Canada, we can distinguish the different justice acts according to a few models. So the JDA was strictly a welfare-based model, focusing on the rehabilitative needs of youth, even though, as I mentioned, maybe they didn't go about addressing these needs in the most effective or evidence-based way. They didn't really rely on empirical evidence. I would refer to the YOA as a failed modified justice model or a failed trifurcated model. I'll use the term trifurcated and modified justice model interchangeably. They're both basically meaning the same thing. The YCJ would be an example of a successful modified justice model, where it's called a modified justice model because it's sort of adaptable to the type of young person before the courts or before the justice system. I'll now go through key principles and ideas behind each of the 5 models, working left from right, beginning with the welfare model. Under the welfare model, sentences or dispositions are individualized. So the response by the justice system to the individual often is less to do with the actual offense committed and more to do with their underlying risk and protective factors and treatment needs. Because it might take varying lengths of time to rehabilitate an individual, this is why sentencing is indeterminate, and I would argue that this would be a fundamental flaw with the welfare model because it violates fundamental principles of justice. Under the welfare model, childcare workers like social workers or probation officers are pivotal because it's their responsibility typically to identify the needs of youth and what their rehabilitation or their treatment will actually look like. And so the main task under this model is to identify or diagnose the underlying causes of crime and respond to those causes through successful treatment. Rather than view crime as solely a product of rational choice, the welfare model sees crime as pathologically determined. Some would argue that it's more genetic, some would argue that it's more environmental, other perspectives would talk about it as being a combination of each of those two. More contemporary welfare perspectives would say we need to look at crime as pathological, but focusing on both environment and genetics. The purpose of the justice system, the reason why we have a justice system is not to punish individuals, but it's to identify the treatment needs of those individuals and respond to those individuals in ways that will promote rehabilitation. The easy way to think about the corporatist model is that it's basically exactly like the welfare model, but it tries to focus on rehabilitation outside of the purview of the state. So instead of using agents of the justice system like probation officers, we're focusing more on true childcare experts. In fact, in Quebec, criminology is a professional degree, just like engineering would be a professional degree in BC or any other province in Canada. In British Columbia, we don't think about criminology as a professional degree. But in Quebec, the idea was we will train undergrad students to be criminologists. That will be their profession. And rather than being agents of the justice system, they'll be professionals in criminology, adept at identifying the needs of the young person in conflict with the law. Like the welfare model, there will be an emphasis on rehabilitation, but it's rehabilitation through diversion, keeping the young person out of the formal justice system, because Quebec basically believed that government intervention was going to be bad. And the best way to avoid labeling effects was to have the young person diverted out of that formal justice system. Under the welfare model, the term pathological was used to describe why individuals offend, and I think this is fairly stigmatizing language because pathology sounds like a disease, and crime isn't a disease. Crime could often be a product of inequity or of oppression or discrimination. I'm not saying that those are the only causes of crime, but there are a lot of causes of crime, and we need to recognize those. The corporatist model would talk about unsocialized youth as the main cause of crime. I don't know if this is the best term either. I think we need to recognize that an individual's environment can certainly influence criminal behavior, but it's not as if individuals were unsocialized or that their parents failed to socialize them. There can be a lot of other environmental factors at play, but still, like the welfare model, the focus here is on treatment and intervention. Those treatment and intervention strategies are sort of developed or designed to try and guide youth away from the formal justice system, as opposed to having formal justice system act as the intervener to treat unsocialized youth. Remember, the YCGA was especially complex, but it was successful because it had that hierarchy of principles. The same thing here with the modified justice model, which was really influential in creating the YCGA. It says we need a lot of different elements. We need to have things like due process, determinate sentences, but it also emphasizes things like informality. And so students might think, well, this sounds contradictory. How can we emphasize procedural justice, which is very formal, and informality, which obviously is not formal? The way that the modified justice model balances these sort of competing aims is by identifying, okay, for non-serious offending, we will focus on informality. For more serious or moderate offending, we will emphasize due process and these sort of procedural safeguards to make sure that individuals' rights are not being violated. The added complexity of the modified justice model means that lawyers become key because we need the lawyers to be able to interpret how the act should be applied. And we also need child care experts, but especially clinicians, to help identify which youth may be more serious in the pattern of offending and therefore require more of a focus on protection of the public and procedural safeguards, and which individuals would be better served through a community-based response, more informal and kept out of the official justice system. So we see that blend of diagnosing the problem that's common amongst the welfare perspective, but also punishment, which we see as germane to both the justice model and the crime control model. The modified justice model recognizes that youth have a diminished responsibility because their brains have not fully developed, their identities and personalities are still developing, and so they are held to a lower standard of blame. The idea is to sanction the behavior but treat the individual, not sanction the individual because of the belief that deterrence will not necessarily be all that effective. And in doing all of this, it's important to respect the youth's individual rights under the law. Now onto the justice system model, which basically excludes the welfare component that we see in the modified justice model. So the justice model is just sort of like a more narrow version of the modified justice model, and it's basically entirely focusing on due process, emphasizing determinate sentences, focusing on offenses and not status offenses or behaviors for which an adult would not be penalized, and using the least restrictive measures, because justice model doesn't mean being punitive, it means being proportionate to the harm done. Not surprisingly, the key people under the justice model will be lawyers because it will be their job to make sure that these procedural safeguards are being respected. The lawyer is there to look out for the legal rights of the young person. The lawyer under the JDA, for example, might be more looking at working with the probation officer to develop treatment and intervention strategies. The lawyer is more, under the justice model, is more about making sure that the young person has the right to a fair trial and so on. The justice model does take into consideration deterrence, so it does emphasize the punishment of offenders. It does believe that deterrence will work. And while it believes that deterrence will work, it also acknowledges that youth are less responsible for their behavior compared to adults, and that needs to be taken into consideration when considering the proportionality of the offense or the sentence to the offense. there is not much of an emphasis or consideration for the individual level risk factors that might be influencing the young person to engage in the crime. The focus is more so on the offense that the young person has perpetrated and figuring out what have other people who have committed the same or similar offense and in similar circumstances received as a sentence. Lastly, I'll talk about the crime control model. And the crime control model isn't always just like eye for eye, send everyone to jail, don't worry about whether they did the crime or not. It's more about also taking into consideration the rule of law, following due process, but also giving judges discretion to make an example out of a person if they believe that they've been involved in a particularly serious offense. Because the crime control model believes that deterrence works, they tend to include in their legislation status offenses because they believe that these status offenses are stepping stones towards more serious behavior. And so if the individual gets punished severely for these status offenses, that will make them not want to engage in more serious offenses in the future. And I think this is probably not the right approach, and I think there's some fairly solid empirical evidence that will show that negative interactions between the young person and the justice system at a particularly young age can only serve to further that young person's involvement in the justice system. Lawyers are important, again, because there's an emphasis on due process. Justice system stakeholders, especially victim rights advocates, can also be key because they will lobby the government or lobby judges to become more strict or more punitive. And so the philosophy behind this model is to incarcerate and punish individuals to protect society, deter other members of society from wanting to offend. That would be general deterrence. And then deterring the individual from wanting to commit offenses in the future because they'll be sent back to jail, so that would be specific deterrence.